All right. 1 minute ago on Friday, February 13, 2026, Ivanka is suddenly linked to new evidence through a late-breaking supplemental packet. Trump goes on offense within minutes, and the judge signals the next move fast. So fast that the entire day turns into a clock. And when your day becomes a clock, mistakes start showing up in public and in the record at the same time. The fictional docket I'm tracking is in the United States District Court for the Eastern District of Manhattan. And at 9:03 a.m. Eastern, a clerk's update posts what's labeled a supplemental evidentiary notice along with a request for expedited conference. And I'm telling you right now, whenever you see those two phrases paired, supplemental evidence plus expedited conference, it's because somebody wants the court to stop treating the matter as ordinary process and start treating it as risk. And the reason this one matters isn't the headline. Everyone will clip new evidence. It's what the packet claims the evidence does. It allegedly tightens the timeline. It allegedly ties intent to sequence, and it allegedly forces a judge to decide whether the next step should be a narrow order or a broader posture shift. Here's the compressed timeline first, because that's how this style works. Saturday night, a sealed entry appears referencing anticipated submission of authenticated records. Sunday morning, a short letter lands from the moving party saying they have newly confirmed materials requiring prompt review. Monday afternoon, defense counsel files a response that's only 2 pages long, too short for comfort, and asks the court to reject the submission as prejudicial in timing. Monday night, the moving party files anyway. Tuesday morning, the clerk posts it and the judge grants a same-day conference window. 3 days, that's all it takes for a case to go from controlled narrative to procedural acceleration. And when that happens, you can almost always trace it back to one thing. The court believes something could be lost, moved, or misunderstood unless it intervenes immediately. Now, quick context, because you need the characters and stakes clear in one breath. In this fictional version, Ivanka is a high-profile business and political adjacent figure facing allegations that blend financial conduct with compliance representations. And Trump's orbit is trying to keep the public story simple. Politics, persecution, family unity, while the legal story is getting more complex. Sequence, records, preservation, intent. And this morning, the moving party claims they obtained authenticated records from a third party that connect Ivanka to a specific chain of actions that the defense previously framed as indirect, administrative, or handled by others. That's the word that matters. Connect, not suggest, not imply. Connect. Because connection is what collapses plausible deniability. Now, what is the new evidence in this fictional packet? It's not a single smoking gun video or a dramatic confession. It's the kind of thing that actually moves courts. Communications metadata, scheduling artifacts, and transaction timing. Think of it like a 3-strand rope. Strand 1 is a communications log summary from a service provider showing routing and timestamps. Strand 2 is a calendar extract with a meeting sequence that contradicts the defense's earlier public framing. Strand 3 is a compliance note trail attached to a transaction that the defense described as routine. Individually, each strand can be explained away. Together, the packet claims they form a pattern that supports knowledge and planning. And the moment that kind of pattern is placed before a judge, the judge's job changes from manage deadlines to manage credibility. That's what you're watching. Now, here's the hook, the part that makes this competitor format perform. Trump goes on offense almost immediately. Not because offense is always effective, but because offense is the one tool political operators trust when they feel the ground shift under them. At 9:16 a.m., in this fictional story, a statement is posted to a social platform from Trump's camp. Short, aggressive, familiar beats, corrupt system, political enemies, unfair targeting, family under attack. The base hears strength. The lawyers hear risk. And the judge, if it's brought up in court, hears noise that doesn't answer the question the docket is asking. What does the record show? And can the parties preserve it? This is where the split happens inside any high-profile operation. The political side wants dominance over headlines. The legal side wants consistency inside filings. And today, the new evidence packet forces those two sides into direct conflict, because if you say too much publicly, you may contradict what you must certify privately. Now, let's walk through the packet and the documents due exhibit style, so you can feel the structure. Document 1 in this fictional set is an authenticated records declaration from a custodian, someone who swears that the attached records are pulled from business systems in the ordinary course with timestamps intact, not manipulated by either party. This matters because courts are allergic to screenshots from anonymous sources, but they listen to custodians. Document 2 is the supplemental evidentiary notice, which is essentially the moving party saying, we have new material. We believe it is relevant. We are notifying the court, and we want guidance on scope. Document 3 is the proposed order, which is where you see what they really want. A preservation certification, an expedited in-camera review of disputed privilege claims, and a narrow production of a defined set of metadata fields. Again, none of that sounds cinematic, but it's decisive because metadata is the timeline's truth serum. You can argue about what a message meant, but it's hard to argue about when a device accessed an account, from where and in what sequence if the record is properly authenticated. Now, what does the packet claim ties Ivanka to? In this fictional narrative, it ties her to a decision window, roughly 72 hours, where a transaction structure was adjusted, communications channels shifted, and a meeting sequence occurred that the defense previously characterized differently. The moving party's theory is not one bad act, it's pattern plus planning. And that's why the judge signals a fast next move, because pattern theories often require quick preservation to prevent the pattern from being obscured. Now, I'm going to do the competitor move where the narrator says, here's what makes this messy. Because that's where the human element comes in. What makes this messy is that the evidence packet in this fictional case allegedly doesn't just implicate Ivanka, it pressures the surrounding team. It raises the possibility that staff, advisors, or intermediaries were involved in routing, drafting, or timing certain actions, which means internal loyalty becomes legally relevant. And the moment loyalty becomes legally relevant, people start rethinking what they're willing to say under oath. That's when panic starts. Not panic like guilt. Panic like exposure. Now, the script style you want also includes the what nobody's covering segment. So here it is. The biggest story is not the offensive statement or the social media clash. It's the judge's posture. Because at 9:41 a.m., in this fictional docket timeline, the judge issues a short-minute order granting the expedited conference and specifically instructing both parties to be prepared to address 3 questions: preservation status, authentication challenges, and the narrowest possible scope for immediate relief. Judges don't write those 3 categories unless they're already deciding whether to tighten the process. And the phrase narrowest possible scope for immediate relief is a tell. The court is looking for an action it can justify as procedural, not political. That's how judges protect legitimacy in high-profile cases. They move, but they move narrowly until they have to move broadly. Now, the defense's problem is that Trump going on offense publicly can make narrow moves look broader than they are because it politicizes the room. That's why in this fictional story, within the hour you see a second, softer statement from a different spokesperson, more legal tone, more process tone, saying they will address the court directly and disputing any mischaracterization of the record. That two-voice pattern, aggressive, then cautious, is the sound of scrambling. It means the operation is not aligned. Now, competitor scripts always include a both sides segment to sound fair and keep credibility with mixed audiences. So let's do it clean. To be fair, late evidence packets can be tactical. Parties sometimes time filings for maximum pressure. Public figures are pursued with intensity that ordinary defendants don't face, and authentication claims, while persuasive, can still be challenged on completeness or context. It's also true in many high-profile stories that media coverage outruns what the record can actually prove. That skepticism is healthy. But here's the pivot back to why the judge moves fast anyway. Even if you doubt the motives, the court still has to manage the integrity of the process. Preservation is not optional. Candor is not optional. And if the new evidence packet creates a plausible risk that the record could be disputed, moved, or misinterpreted later, judges often act early to lock it down. That's not punishment. That's prevention. Now, let's go into the conference itself, because this is where the judge signals the next move. 2:10 p.m. Eastern, February 10th, 2026. The parties appear for the expedited conference in this fictional court. The judge, let's call her Judge Elena Marquez, opens with what judges always open with when they smell fog. She asks for a simple timeline, not speeches, not accusations. Walk me through when you learned of these records, when you requested them, when you received them, and what you want me to do today. The moving party responds with a tight chronology and leans on the custodian declaration. The defense objects to timing, claims prejudice, argues the packet is an ambush. The judge then asks the question that reveals what she's thinking. Is the defense contesting authenticity, relevance, or scope? Because those are different fights. Authenticity is about whether the records are real. Relevance is about whether they matter. Scope is about how much the court should order right now. And the defense in this fictional scenario avoids saying inauthentic too strongly, because accusing a custodian-backed record of being fake is a big move and instead leans on scope and context. Even if authentic, it's incomplete. Even if relevant, it's being misread. Even if timely, it can be handled on normal briefing. That's a standard defensive posture. The judge's next move is the signal she doesn't accept the idea that this can wait. She says something like, "I'm not ruling on merits today, but I am ruling on preservation and process." And then she issues a fast procedural directive. Within 48 hours, the defense must file a sworn preservation certification covering specified categories. Within 72 hours, the moving party must provide a narrowed list of metadata fields requested. Within 5 days, the court will conduct an in-camera review of the most contested items to decide if privilege is being asserted properly. That's the signal. That's the judge saying, next move is not political theater. Next move is tighter control. Now, why does that matter for Trump going on offense? Because offense works in media, but it doesn't work against process. Process doesn't care. And when a judge narrows the dispute into certifications, indices, and in-camera review, the battlefield moves from public rhetoric to sworn filings. That's where teams scramble because sworn filings require alignment, and alignment is hard when you have multiple power centers, political strategists, legal counsel, advisors, and family voices. Now we hit the competitor expert course section because it gives the audience a ladder of authority. Former federal prosecutor voice, fictional. When a judge orders preservation certification after a supplemental evidence packet, it's often because the court is concerned about either spoliation risk or candor drift. Digital forensics specialist voice. Fictional. People think deletion ends a story. Metadata often starts it. White-collar defense attorney voice. Fictional. The worst moment for a high-profile defense is when the story becomes about the timeline rather than the allegations. Constitutional law professor voice. Fictional. Offensive public messaging can complicate courtroom posture when the judge is emphasizing process. And then the key line the competitor style loves, when both sides agree on one thing, pay attention. In this story, even sympathetic commentators concede that once the judge signals fast procedural moves, the smart play is to get quiet publicly and get precise privately. Now, let's widen stakes because this script style always ladders from personal drama to systemic impact. Why should you care? First, because high-profile cases change baseline court behavior. If courts start tightening preservation and ordering quicker conferences in high-visibility matters, it becomes easier to justify similar measures against ordinary defendants later. Second, because the political ecosystem reacts to legal acceleration with fundraising messaging and polarization, and that spills into election dynamics whether you like it or not. Third, because markets, donors, and institutions hate uncertainty, and nothing creates uncertainty like a legal process that suddenly speeds up. But here's the uncomfortable part the script must say. The story isn't only about whether someone did something wrong. It's about whether powerful people can maintain narrative control when the record starts speaking louder than the spokesperson. And today, in this fictional scenario, the record just got louder. Now, we bring it back down to the emotional core because competitor scripts always tie the legal to the family. Trump goes on offense because that's his reflex and his brand. But the filing creates a credibility corridor he can't muscle through without risking contradiction. Ivanka, linked to new evidence by the packet's pattern claim, becomes the center of a procedural tightening. The judge signals the next move fast by focusing on preservation, authentication posture, and narrowed immediate relief. And the team scrambles because public unity and legal precision are not the same thing. And here's the final twist beat to keep retention right to the end. The judge's fast procedural order in this fictional story includes a line about any party with knowledge of device custody being obligated to ensure preservation. Language that subtly widens the circle beyond one person. That doesn't mean guilt. It means responsibility. And when responsibility widens, operations panic because now everyone has to be careful. That's why you see the messaging shift by late afternoon. The offensive statement stays up, but a second statement appears emphasizing respect for the court. Allies are instructed to stop speculating, and insiders begin saying, "Let the process play out," which is the polite way of saying, "We need time to reconcile." Now, where are we right now in this fictional story? As of Tuesday, February 10, 2026, Ivanka is linked to new evidence by an authenticated supplemental packet. Trump has gone on offense publicly. The judge has signaled the fast next move by granting an expedited conference and issuing preservation-focused directives. And the next 72 hours matter more than the next 72 news cycles, because the next filings will determine whether the court treats this as routine or treats it as credibility risk. Dates to watch in this fictional countdown. Thursday, February 12th, deadline for the defense's sworn preservation certification. Friday, February 13th, deadline for the moving party's narrowed metadata request list. Tuesday, February 17th, in-camera review session and follow-up status conference, where the judge decides whether scope stays narrow or expands. If the certifications align and the disputes shrink, the case stabilizes. If the certifications reveal gaps or contradictions, the court tightens and the story accelerates. That's how these procedural stories turn. And if this breakdown format helps, if you want the next packet decoded the moment it hits, subscribe and turn on notifications. Because in this genre, the real cliffhanger is never the rumor. It's the next filing. And the next filing is always where the timeline either collapses or survives.